Good morning or good afternoon, depends on where you're at, and welcome back to Trial Watch with Demetra Lit all day. That will be myself. It is a Friday here where I'm at, and it's a beautiful day so far with a cold front coming. So I hope that wherever you're at, whatever you're doing, you're having a very successful and productive day. And I thank you for joining me either in the live or in for the replay action. If you come through on the replay, please let me know by leaving me a comment. Be counted. Happy Friday, Barry Carey. Thank you for coming through and supporting. Baby, I don't know where the Lit Lane jury box at, but they'll get him. But justice waits for no one. So we are continuing today, and this is actually the conclusion live for the trial out of Florida. It's been dubbed the Forgetful Granny trial. This is a trial of, they coming, right? This is the trial, not featuring, where the defendant is a Miss Tracy Nix, grandmother, 67 years old. Tracy Nix is accused of and in standing trial now. Hey, living for unaliving by way of leaving the baby in a hot car her 7-month-old granddaughter Uriel. She's been charged with manslaughter and a few other charges, but the highest one, the most grave charge is of course the manslaughter. Now, what makes this case really stand out, besides the unfortunate tragedy with the baby, that's big enough, but it really stands out because of the fact of this is not the first grandchild of Tracy Nix that has perished under her care. In that same year, 2022, around March, she fell asleep while supervising and taking care of her grandson Ezra, baby Uriel's brother. Somehow, some way, he drowns and didn't survive. And then that was in March of 2022. That same year, in November, she was taking care of her granddaughter, 7-month-old Uriel, and leaves her in the car for hours in 90-plus degree weather. The first time with Ezra, she didn't face any criminal charges, any criminal consequences. But as you can tell by us being here today, that was not the case with the second baby. One fact about this case, something you should know, is the judge omitted and forbade any information about the first grandson's drowning. So this jury is sitting and listening to this trial, listening to this situation about baby Uriel with no clue that this is not the first time something like this has happened. So again, thank you guys for joining me on part two. It's more than part two. This is the conclusion. The conclusion of the Forgetful Granny trial watch. We're starting in real time for the trial. It was yesterday, and it was day 2. It was a really quick, swift trial. So let me get that started here. Of course, I'm going to be reviewing this under fair usage. Let me put that up really quickly. Hold on. Fair use for review and critique and an effort education, an effort to learn more so and see our United States justice system at work, and discuss the issues that happen every day to day in our communities. Hey, bother for real. Welcome back to the Lit Lane Jury Box. Welcome back, Lou A, to the Lit Lane Jury Box. Okay, let's take this down. Boom. And let's get started. First witness of the day. We're going to get through this trial today. And thank y'all for hitting the like, sharing, and always showing up. There go a little friend right there with them glasses. The defendant is a retired school teacher. She spent 17 years actually as a principal before retiring. Bible school, Sunday school teacher, church choir director. Oh, the community showed up, huh? It's a packed house. Okay, Living, I understand. Thank you for coming through and always coming through, always being here. Thank you. Okay, let's get it started. So we're going to get through this route today.
Juror 1, have you heard anything or seen anything about the case? Juror 2, have you heard or seen anything about the case? No. Juror 3, have you heard or seen anything about the case? Yes. Juror 4, have you heard or seen anything about the case? No. Juror 5, have you heard or seen anything about the case? No. Juror 6, have you heard or seen anything about the case? Juror 7, have you heard or seen anything about the case? No. Juror 8, have you heard or seen anything about the case? Yes, sir. Okay, we're going to be in our final day today, so pay close attention and we're going to begin. State, call your first witness for the day.
Yes, Your Honor. The state calls Dr. Vera Volnick.
This is the first medical witness.
And just putting,
Please, absolutely.
More, Doctor. Please raise your hand. Do you solemnly swear or affirm that the truth and nothing but the truth?
Doctor, you're going to step this way.
That weird sound is on the actual stream.
We've got some water in it.
You ready, Doctor?
Yeah.
And if you could please speak up and state your name for the record, Doctor, please. State your name.
My name is Vera Volnikh. It's Volnikh.
And how are you employed, ma'am?
I employ as Associate Medical Examiner at the District 10 Medical Examiner Office.
And how long have you been a medical examiner?
20 years.
Could you give the jury a brief idea of your educational background?
I graduated from medical school in Havana, Cuba. I completed my postgraduate training in pathology at the University of Puerto Rico.
Welcome back to the Little A Jury Box, VA Sash. Thanks for joining. Happy Friday.
At the University of South Florida. And after that, I was employed at our current office here in the District 10.
Are you a licensed physician in the state of Florida?
Yes.
For how long?
21, 22.
And you said you're a medical examiner. What are your duties as a medical examiner?
The main duty of medical examiner is to determine the cause and manner of death, or how is the person died and why is the person died.
Approximately, and are autopsies a regular part of what you do?
We perform about 300 to maybe 350 autopsy per year, every year, depends. Sometimes less, sometimes more.
So approximately how many autopsies do you believe you've performed?
In 20 years?
Yes, ma'am.
Ooh, a lot.
That's an understatement,
Fair
huh?
enough, ma'am. I think you've given us an idea of the numbers that we're dealing with, unfortunately. In your personal experience as a medical examiner, have you performed any autopsies on infants?
Okay, just to let you guys know, I am looking for a different stream because that sound is irritating me. It's with the original stream. Hopefully, I'll find another one that we can watch. But until then, sorry for the inconvenience.
Yes.
Let me ask you this, Doctor. You mentioned some practices. What is forensic pathology?
Again, the main goal of forensic pathologist or medical examiner to determine the cause and manner of death, or how is the person died and why is the person died.
And have you ever testified as an expert before, Doctor?
Yes.
And how many times?
Many.
Many times. Have you testified as an expert in your area in Polk County previously?
Polk County, Hardy County, and Highlands County, which is our District 10.
Your Honor, this time the state would tender the expert as far as qualifications are concerned.
Defense? Objection. All right, doctor, you are considered an expert in this court size and for the jury. Thank you. You're an expert.
Doctor, I would like to now direct your attention to November 2nd of 2022. On that date, were you asked to perform an autopsy on a baby by the name of Uriel Shock?
Well, I was not asked. Once somebody dies in our jurisdiction, we get a call, depending where the body is. Hospital, the scene, we will get the call to our office. Somebody present out the case. We determine that the case, medical examiner case. Once we determine it's our case, we will dispatch our transport to the place where the body is located, and we will bring the body to our office. Once the body arrives at our office, whoever on that day on duty will perform the autopsy. So we are obligated to do that.
Pardon my poor choice of words. I guess I should have said, were you obligated to perform the autopsy? So you did perform an autopsy on Uriel Shock?
Yes, it's of course it depends case by case. Sometimes we don't perform autopsy if we have enough information. Let's say somebody been in the hospital, we get review of medical record, medical history, and we may determine the cause of death, including the manner of death. But in the infant or children's, we almost always perform the autopsy to see what happened.
Why is that, doctor?
Well, children cannot talk, infants cannot talk. Sometimes we have to exclude all the possible causes of death, like trauma, intoxication, any diseases that the children may have, which was not diagnosed. So we have to look at that to determine the cause of death.
And in this situation, how do you normally start out conducting that process?
Well, in this particular case, we get the call from the hospital, and they say there was a child that left in the car for several hours. So we say, okay, this looks suspicious, so we will bring the body to our office to examine. Again, we dispatch our transport. The transport will place the body in the body bag as is, seal the body bag, and that bag will be transported to our office. Once the body arrives at our office, we will open the body bag. We will take serial photograph of the body as is in the body bag with any medical equipment attached or any clothing that on the deceased. After that, we will remove the body out of the body bag. We will remove all the medical devices, clothing. We clean the body, and we'll take another serial photograph of the body, front, back, from all the angles. The reason we do that is to show presence or absence of any injury on the body. That's what we do. And
if I may, doctor, in this instance, since we're talking about the external examination, did you notice any of that, any evidence of any trauma or anything like that?
When we do the photographs, it's kind of part of examination, but we just do for preservation purposes, we do all these photographs. And when we say then we decided, okay, we're going to do autopsy. Autopsy has two parts. External examination, which include looking at the body.
Okay, so we're gonna fast forward through some of this.
She
Okay.
died and she eat last time. Again, I don't know what time she eat, but it's not instant death.
Okay, and so that just so it's clear, when you say quickly, you're not talking 5, 10, 15 minutes.
Again, quickly doesn't mean instant. It's not instant death. She was, alive to produce all that sweat that this child have, because when we receive these kids cases, we have also information from, let's say, EMS, law enforcement. So we read all the report. And we know that the child her clothes was completely soaked of sweat. So that means that child was alive for some time to produce produce that amount of sweat. So again, quickly could be an hour. If the temperature rise very fast, very high, she cannot, even the adult cannot sometimes overcome the hyperthermia. In the children, it's even worse. They get very hot very quickly. So again, they try to sweat, but because they cannot overcome that insult, so they became unconscious first, and then they die after the brain dies.
So is it fair to say that when you use the term quickly,
Overruled.
so when you use the word quickly, it's more of a term of art compared to hours compared to days? Would that be safe to say?
Correct.
All right, no further questions.
Okay. May this witness be excused?
Yes, sir.
Defense, do you agree? All right. Thank you, doctor. Have a nice day. You're free to do your business.
Thank you.
Boy, that's the fastest ever I've seen a medical examiner testify, ever.
All the evidence has been entered. I checked the clerk. The state will rest.
All right, state rest. Let's take
Okay,
a
state
break.
rest.
All rise.
Now the defense case puts on its
Get
case.
you back here in a few minutes.
Wow, moving so fast.
Case that defense is trying to present to the court.
Okay, through the magic and wonder of YouTube, we fast forward to the next witness. I believe this is Tracy Nix's husband, Nate.
Can you step this way, sir?
Thank y'all for joining.
May it please the court.
Yes, sir. Go ahead, Mr. President. Thank you.
State your name for the jury, please.
None, Nix.
And Mr. Nix, you're the father of Kayla Nix.
Yes, sir.
You're the father of Rebecca Tucker,
Yes.
and you're the husband of Mrs. Nix.
Yes, sir.
Okay. All right. And obviously you remember Yuri.
Yes, sir.
Okay. How often would you and or Tracy keep Yuri?
Depending on the week, anywhere from 2 to 5 days.
Okay. Can you give we'll say a normal routine on how that would occur, the pickup and the delivery?
Most often would be me going to their office to pick up the child. And then I would bring her back to the house. And that's where usually Tracy would pick up.
Would pick up from there?
Yes.
Okay. And when you would drive to pick up Yuri, what vehicle would you drive normally?
Normally was my truck,
Normally.
pickup truck. Yes.
Did you ever drive the red Lexus?
Yes, sir.
Okay. And in the evening, how would she get, we'll say, redelivered to her parents?
Normally was her father, Drew, would normally come by after work.
Okay. And on occasion, did you drive the Lexus
Yes,
to either pick up or redeliver
pick up.
the child? Okay. And when you had the mirror adjusted to the back, were you able to see the car seat from the back seat, driver's side?
No, sir, not for me.
Okay. Now you're a little taller than Tracy.
Yes,
Okay. Can you tell us, would Tracy be able to, from her viewpoint, from what you saw in the Lexus?
Judge, it's speculation.
Sustain.
If you're looking out the back window from the rear view mirror, is your view going to be the same as hers if it's properly adjusted?
yes.
Okay. And did you ever, we'll say, have a situation where you got into the car and it was adjusted for Tracy?
Yes.
And y'all have some issues about that sometime?
Some minor discussion.
Okay. All right. Thank you.
State, any cross?
Briefly, Your Honor.
Wow, that's it.
Mr. Nix, I just have a few questions for you. As far as the vehicle, the Lexus, it has windows, right?
Yes,
You can see through those windows?
yes.
No further questions.
All right, redirect.
Yes. On the day in question, could you see through those windows?
Yes,
And on the day in question, before Yuri was found in the back seat, were you near that vehicle on your lawnmower?
yes.
And could you look into the vehicle?
Not from where I was seated on the lawnmower
Okay, and why was that?
because I was located a small distance from the car at approximately the same height as the driver.
Okay, and you could not see the child?
No,
Okay, thank you.
All right, he may be excused. Fletcher, may he be excused?
Yes, Your Honor.
Okay. Yes, sir. Thank you, Mr. Nichols.
Very interesting point, Virginia. I mean,
Yes,
yeah,
Brett.
I can say Virginia. BA says this is so sad that he has to defend his wife against his daughter. Very true. I hadn't even thought about that part. You want to talk about swift justice? This is a perfect example, right?
Court decision. You have the right to remain silent. Has anyone forced you not to?
Wow, I did not expect this. I had no clue, Lit Lane Jury Box. I had no clue that Tracy Nix, the actual defendant in this trial, was going to take the stand. Wow. So on the stand, surprisingly, it's Tracy Nix. Let's see what she has to say. Wow. I'm just flabbergasted. I didn't know this. Give Miss Steph 219 up in the clouds. My. On screen right here is the parents of both Ezra, who his death is not being submitted or talked about in this trial, and also a baby Uriel, who this is her trial, her manslaughter trial. 7-month-old victim of hot car, left in a hot car. So that's who they have on the camera on now. Welcome back, Pretty Glow Aesthetics. We on the conclusion live for the Forgetful Granny, and guess what? The grandmother is actually taking the stand. Welcome back, Foot Soldier. Right in time. We got a surprise witness, the defendant herself. Please hit the like. Taking a stand is Tracy Nix.
We're back on record, Mr. Fletcher. Did you have sufficient time to consult with your client?
Yes, sir.
Is it still her intent not to testify?
That's correct, Your Honor.
All right, so Ms. Nix, you had a conference with your attorney outside, and it's your intent not to testify.
That is correct.
Has anyone forced you not to testify?
No, sir.
Has anyone
Oh, she ain't
prompted you in
testifying.
any other- well, to get you not to testify?
No, sir.
You understand you have the right to take the stand to testify.
I do.
You understand that decision is totally up to you to testify or not, since it's your decision.
I do understand.
And whether you testify or not, that's in your sole mind, and it's not based upon what your lawyers are telling you or not telling you. That's your personal decision.
That's correct.
And you understand lawyers give advice. If you choose to testify, then the state will cross-examine, and you will have your way to right to remain silent and testify on your own behalf, just as any other witness.
Yes, sir.
All right, with that being said, I find you knowingly and intelligently has waived the right to testify and will be sitting at council table. And go ahead and speak.
Got me all hyped for nothing.
Plus minute
I
break.
forgot they got to get up there regardless.
Together, please make sure we have.
Sorry, y'all.
with
I didn't mean to
sufficient
mislead
copies.
you.
We're gonna go right into, let me double check. I'm gonna give the closing argument.
Well, that's why it was going to be so surprising to me. A lot of times these folks don't take the stand.
Yes, Your Honor, and just so make sure the state understands, you would like copies
And
of
it
the-
seems like, really truthfully, the ones that do choose to take the stand more often than not are really narcissistic
Correct. And then the verdict
and as
form will have
guilty
copy
as
of
can
the
be. Not
amended
all the
instructions.
time.
It's separate
Okay, of
copy.
course not.
Okay.
To put
But a
that
lot
on
of
for
the times when we see the
Anything on
defendants
that
take the
first
stand,
page, the
they're
defense plan
grade
states
A narcissists.
the attorneys say is not evidence or your instructions.
So
on
that's
law. However,
really
if
why
you
it would have
closely,
surprised me had she actually
they are
testified.
intended to aid you in understanding the case. Each side will have equal time, but the state is entitled
We
to
finna get into
provide
these
its
closing
time for an
statements.
opening argument and a rebuttal argument after the defense has given its closing argument. State, you prepared?
Let's go.
Please, the court.
Closing arguments.
Counsel.
Yes, Your Honor.
And she just had her to suffer, and she just boiled to death.
Members of the jury, as we go through our lives, one of the early lessons we get is everybody makes mistakes. Most of the time, we apologize, we accept responsibility, and we move on. Unfortunately, some of us in this room might have learned sometimes sorry is enough for those mistakes. Sometimes those mistakes carry dire consequences, and sometimes those mistakes are crimes. And that's why we're here today. And I would argue to you that is why the legislature of the state of Florida passed the very laws we're here today that the defendant is accused of. So in order to discuss this case, to discuss the facts, what's important first is that we discuss what I believe you're going to be instructed on as far as the law related to this case is. You will receive copies of these, so please, you don't have to write furiously. What I believe the judge is going to tell you is to prove the crime of aggravated manslaughter, the state must prove the following three elements beyond a reasonable doubt. One, Uriel Jane Shock is dead. Two, the death of Uri was caused by the culpable negligence of Tracy Nix. Three, Uri was at the time a child, and Uri's death was caused by the neglect of Tracy Nix, a caregiver for Uri. Now, I just want to get out in front of it and just tell you, I believe the crux of this case, what everybody's going to be talking about, what you yourselves are going to be talking about, is number two. Culpable negligence. What is it? So, but it is my job, it is my burden as a state to prove the crimes. And even though 1 and 3 are not in dispute, we're going to talk about it, get those out of the way, and move on to the crux of the case. So, 1, Uriel Jane Shock is dead. The court instructed you, we've agreed. The parties have agreed. She's dead. That's not an issue. Skip to 3. Uri was at the time a child. Once again, that's not in question. She was 7 months. And her death was caused by the neglect of Tracy Howard Nix, a caregiver for Uriel Jane Shock. Was caused by the neglect. So just from that point, just neglect. She left her in that car. That's not in dispute. What's in dispute is whether or not it's culpable negligence. There's no dispute on whether or not it's neglect. A caregiver, there's no question. As the judge will inform you, a caregiver means a parent, adult household member, or any other person responsible for the child's welfare. She was Uri's grandma. She was the sole caregiver at that time for Yuri. Yuri was solely dependent on her for care. So I would argue to you, members of the jury, that 1 and 3 are not in dispute. So let's talk about 2. Before we get there, there's this language that we're going to get to in culpable negligence that may be confusing, but it's clarified by what the judge is going to instruct you on what we like of a child of needs. It means a caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to, for the well-being of the child. Here's the thing. Neglect may be based on repeated conduct or a single incident. Repeated conduct or a single incident, or omission by that caregiver. They didn't do something. So I want you to keep that in mind, please. So we'll turn to it. The death of Uriel Jane Schott was caused by the culpable negligence of Tracy Howard Nix. Remember, it could be a single incident. I anticipate the judge is going to tell you that aggravated manslaughter, he's going to tell you at first, every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence, simple negligence. So it's interesting, and I want to discuss that for a moment before we go on. How are you given the definition of culpable negligence? We define simple negligence. Culpable negligence is, you can have negligence, but it can become more based on the facts and circumstances. It's important. The definition of culpable negligence is started by giving you the definition of simple negligence. The defendant cannot be guilty of aggravated manslaughter by causing the death merely from a negligent act. But culpable negligence is more than the failure to use ordinary care. In order for the negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing a reckless disregard for human life or the safety of persons exposed to its dangerous effects. See, that course of conduct is one way. Or safety of persons exposed to its dangerous effects. Safety of persons exposed to being left in a hot vehicle. It fits there. It fits there. Or shows wantonness or recklessness, or grossly careless disregard for the safety and the welfare of the public, or indifference to the rights of others. The negligent act or omission must have been committed with utter disregard for safety of others. That's what we're talking about here. Those are the types of things that we're talking about. So when we start to talk about culpable negligence and what it is, that definition, I think, sets the stage of how you're to analyze. First, was there negligence? Second, was that culpable negligence? Follow that definition. So how do we determine what culpable negligence is? We just don't look at the act. We look at everything surrounding that act and the results of that act. That's what gives you culpability. That's what gives you criminal negligence. So in order to discuss that and have a conversation about that, I think we just need to go through briefly a rough timeline. We don't have anything set in stone, but we have good witnesses who testified, and we have an idea of exactly what happened that day. Around 9:30 to 11 a.m., there was some testimony, it might have been 10. Regardless, there was that prayer meeting. We heard from the two nice night ladies, Judy Terrell, the defendant herself. That's where she started out that day. Sometime between 11 and 12, she agreed to pick, she being the defendant, agreed to pick up Yuri that day. We know that she talked with Taylor. She at least messaged, and we do see on her phone around 11:18 that there was a conversation. Sometime between, and at that meeting is when they have from the prayer meeting from 9:30 to 11, lunch is discussed. We're going to meet at these. The agreement to pick up Yuri, I pick her up first. That's Gail goes along with her. Sometime between 12 and 12:30, we know from the time stamp at beef, she got there around 12:30. Between 12 and 12:30, she picks up Yuri. When she goes and gets Yuri, she gets a diaper bag with the supplies. She gets everything she needs to provide the care a responsible caregiver would give to that child. She picks that up. She also picks up a car seat and places it in her back seat. Once again, a responsible caregiver. She's provided all of these tools to do what she needs to do. So she gets that car seat, places in the back seat of her car. 12:30 to 1:45 is roughly about the time the dart beeps. You saw the video, a portion of it. It's all there for you to review when you go back there if you choose to. We know around, it's that 1:45-ish area that she left, because one, we know from all the three ladies that were with her, Gail had to be out of there. And they know, they looked at their watch, it was 1:40 when they started leaving. And we see on the beef's been injured from that point. But there is no doubt that more than 15 minutes elapsed. And in doing so, Tracy Howard Nix caused great bodily harm to Yuri. What greater bodily harm is there than death? That's all the time I'm going to spend on that count. I believe that count, it's unequivocal. It's there. So let's focus more on her actions. Let's talk about culpable negligence. Let's talk about wanton and reckless. We have to look at those circumstances surrounding. It's easy to say, oh, she just forgot. That's simple negligence. Well, that's the only way. If she did it on purpose, she'd be charged with murder. We charged her with culpable negligence. So yes, forgetting something is simple negligence. Forgetting to lock your door when you leave your house, simple negligence. Forgetting to take the food out of the stove, simple negligence. Maybe even forgetting that you were the parent that was supposed to pick up the child who's safe at school, but has to wait another 10 or 15 minutes because you forgot. Simple negligence. Leaving a child unattended in a car for 3 hours in the hot Florida sun baking. That's not simple. No matter how you slice it, that is not simple. Yuri's death was not simple. Let's talk about that. We have to look at those facts and circumstances. It's not just the forgetting, but we have to look at what her duty was that day. She was the sole person responsible for the most vulnerable thing we have in our society as human beings. A baby. A baby. You have a heightened duty. You're in charge of something that literally can't live without you. She can't open that car door. She can't even get herself out of that car seat. She can do nothing to protect herself. She relies on someone to do it for her. She relies on a responsible person who keeps her first in her mind, who knows her duty, who knows this is a great responsibility. And we know that she knew that, and we'll talk about that in a minute, because she did that earlier. But she just got back to the house. I'm home. Let me do what I need to do. Yuri deserved to be the primary focus in her mind that day. But she wasn't. And that goes towards the culpability. That goes towards the criminality of her negligence. That's why this happened. You have, when she is in your possession, she is your focus. She should be the first thing on your mind. Now, let's continue our discussion about the facts. She picked up Yuri. Now, I know it was something that she wasn't expecting to do, but she did. She picked her up. She went and she got the diaper bag, she got the car seat, she got these, as I said earlier, were the supplies to ensure this child's safety. Members of the jury, the diaper bag was edited in evidence. And all those supplies are still in here. And you could feel the weight almost as much as Yuri herself. She had everything she needed to protect her, to care for her, to ensure her survival. She had a car seat. She had everything she needed. She's the one who put it in there. At this point, Yuri should be the only thing on her mind. Yuri should be the primary focus on her mind. Again, the diaper bag. We can see the supplies, the bottles to feed her, the clothes to clothe her, the medications to give her. You can just see the volume of stuff that she had. Again, why do I show you all these things? These are the things that should push Yuri to the forefront, that should make her the priority. The car seat placed in her vehicle. She's there. She's there. And what did she do when she went there? She didn't just immediately go home and say, oh, I forgot I had her. She went to lunch for an hour. Let's talk about that. The time it leaves. She's over there. She's there for over 1 hour. She comes to the restaurant. She didn't leave Yuri in the car then. Yuri's with her. She brought in the diaper bag. And as a matter of fact, you see constant attention on Yuri. As a matter of fact, Yuri was not only the center of attention for the defendant, she was the center of attention for everybody there. There's something innate in human beings. When you see an infant like that, there's just a need to protect, a need to pay attention. And you could see that in the people around her. You could see that in the defendant herself. So why is this important? As I stated earlier, there she is. On her lap. The focus of her attention. Oh, she almost pushed off the bottle. Again, this is the thing that should be reinforcing in this caregiver mind, in this caregiver's mind. This is something I need to protect. This is something I need to look out for. Then she left these. She took Yuri with her, didn't leave her in the restaurant, took her with her. Put her in the car seat. You can see the blanket over her shoulder. She brought everything out, didn't leave anything behind there. Put the diaper back. And then what'd she do? Drove straight home. And we saw her when she was leaving these. There she is. Diaper bag, white blanket, baby in hand. Even the food. Didn't leave the food behind, had a friend bring it. There it is. Being placed right in the vehicle, Yuri, in the car seat. She knows she has Yuri. She knew it. She placed her in that car seat herself. That's right behind her driver's seat. She's driving an SUV, but it's not one of those giant SUVs. It's not a Hummer. It's a small vehicle. She put the diaper bag in there. She put the blanket in there. All these things. And then where did she go?
Was it just you and Yuri on the floor? Okay. And about, no, when you got back to the house, did you make any stops in between?
No stops in between, straight home. Straight home from spending an hour at lunch, fawning over little Yuri. Didn't make any stops, no interruptions in between. Straight home. And what did she do when she got home? Well, parked her car, got out of her car, closed the door, and went about her business. What kinds of things would she do?
Okay.
And I played the piano. And I practiced for a long time. I can't believe I didn't even think of it.
So you went straight home and you started talking to your dog?
Yes.
Okay. And what's your dog's name again? Macy.
So what is she doing? She goes home, gets out of the vehicle, got to go talk to the dog. Got to go practice my piano. I'm working hard at it. As I said, got out of her car. Meanwhile, Yuri's left in that vehicle on a hot Florida 90-degree day. 3 hours. What is she doing in that 3 hours?
And when you went inside after getting home, what did you do?
I went to the piano. I think lessons I have one on Thursday and I need to just put in time on it.
Okay.
She's practicing her piano, and Yuri's body is fighting the heat.
I was thinking my other grandson was supposed to take it out for dinner.
Okay.
And I was impatient because they were about an hour behind. And I finally got in the car and went down to the barn because they had to go feed the pig, for 4-H pig. And all of a sudden, when I got out of the car, it came across my head that I had Yuri and what happened. And Ken can pick her up and couldn't remember what happened.
She was more focused on her meeting that she had planned with her grandson than the 7-month-old whose body was fighting the heat in the car while she was thinking about all this stuff. Didn't even dawn on her.
Now, just so I understand correctly, Ms. Tracy, you said that you were gonna get your other grandson for dinner. Okay.
That had been planned for several days.
Again, that's the thing that is more important to her at the time that she's thinking about. Getting out, taking care of the dog, playing the piano for an hour. Plans that she had made the day before, ignoring the plan that she had made that day and that obligation that she made that day to protect that child.
After 4:30, got in the car so that I would be there when they were feeding the pig and we could go.
She actually got back into the car to go feed the pigs. Got back into the car where Yuri, at 4:30, where Yuri's been now for 2.5 hours on her own. Still, nothing.
About how long after 4:30 did you realize that she was in the car?
And that talked today, probably 5 to 10 minutes, with him sitting on the mower and me sitting in the car. And then I got out because Rebecca.
Toward others. And this is what the judge is going to read to you. If there's a violation of that duty without any conscious
I don't know why it
intent
skipped
to
like that.
harm,
It wasn't me.
that violation is negligence. That's what we have. Read it again. Every person has a duty to act reasonably toward others.
Welcome back, Kerr.
If there's a violation of that duty without any conscious intent to harm, that violation is negligence. Conscious. Where have they shown you anywhere that Tracy Nix consciously did this? Now, this is culpable negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. She forgot. That's the act. That's not culpable negligence. Forgetting. It's more than a failure to use ordinary care toward others. In order for it to be culpable, it must be gross and flagrant. Again, separate the act from what actually the result was. You have to separate the two. It's got to be gross and flagrant. She forgot. She simply forgot. Grandma forgot. Culpable negligence is a course of conduct showing reckless disregard of human life. Do you think she intentionally left this child in this car? Can you possibly, after seeing those videos, even think for a second that she intentionally and recklessly left this kid in this car? She forgot. Simple negligence, ladies and gentlemen. Now, I'm just reading the jury instruction. Culpable negligence is a reckless disregard of human life or the safety of persons exposed to its dangerous effects, or an entire want of care as to raise a presumption of conscious indifference to the consequences. Do you think for a second that she had a conscious indifference to the consequences? Again, she forgot. The results are horrendous. That's a separate element. They have to prove culpable negligence, and they can't do it. They can put on diaper bags. They can put on this timeline. They can put on this video from Beef O'Brady's, but none of that shows culpable negligence. This is extremely high burden of proof that they have to prove beyond a reasonable doubt. Continuing, wantonness or recklessness, grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of rights. Did they come anywhere close to showing any type of intentional violation of rights? It has to be tantamount or equivalent to an intentional violation of rights. Culpable negligence is consciously, and again, I'm continuing reading the jury instruction. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. This is replete with gross, flagrant, conscious disregard. There's nothing here to show that. They've shown simple negligence. Again, every person has a duty to act reasonably toward others. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. Again, that's what we have. These are very serious charges. I ask you to deliberate, read these instructions at 7.7a, and look at the definition of culpable negligence. They have not proven it. The whole issue here, again, is culpable negligence, and she forgot when she got home. And you say, well, why did she forget? I don't know. The brain's a strange thing. Why did she forget? Was it age? Distractions? They had the roofers there that day. You had other plans. But again, she simply forgot. She simply forgot. And when she remembered, well, you saw what happened when she remembered. You know, Tracy Nix has to live with this forever too, carry that burden for what happened that day. But again, it was simple negligence. When you forget, you forget. And when you remember, why do you remember again? Now, I'm sure every one of you, regardless of your age, has had an incident or a number of incidents where you're supposed to pick up something or somebody on the way to work, and you get to work. You're supposed to pick up something at the grocery store on the way home. You forget. It's simple negligence. It was simple negligence here. The state was wrong when they said that there's a higher duty when it's a child. That's number 3. That's not number 2. There's nothing in culpable negligence that talks about babies as opposed to anybody else. You have to look at that. The actions of Mrs. Nix. The actions, not the results. There's nothing we can do to bring this child back, ladies and gentlemen. And again, I urge you to look at the definition. Again, he's taking simple facts. He's turning that into culpable negligence. And please don't make this terrible situation worse by convicting Tracy Nix of something that she's not guilty of. Thank you.
Thank you, Professor State.
No, sir. No, sir. No, sir. No, sir. I'll hold what I got.
I started out when I spoke with you folks, discussing mistakes, and sometimes sorry isn't enough. And I would argue that the judge is going to instruct you on something that agrees with you. The court's going to instruct you that this case must not be decided because you're for or against it, because you feel sorry for anyone or angry with anyone. And I agree with that. No matter which side, we're human beings. I apologize to you, the jury, because we asked you to do something impossible, which is set aside what makes you human, your emotions, but you have to do it. And I stress, and I would agree, and I would echo, look at those facts. Those facts reveal the truth. Those facts reveal the crime. Don't make that decision because you sympathize with her. Don't make that decision because you're angry at her. Make that decision because she did it. That's what you need to make your decision on. I do want to spend a few moments of my time addressing some of the things that the defense said. Yuri, she isn't milk. She isn't groceries. She isn't an unlocked door. She isn't the pet you forgot to walk. She was a 7-month-old baby. And yes, you have to consider that when you consider whether something's reckless. What would a reasonable person who's in charge of a 7-month-old, who is responsible for her life, her survival, what would they do in that situation? The defense wants you to take the simple act of forgetting and focus on that and say, you can't look at the results. You can't look at the other factors. No, members of the jury, you have to. That is what tells you whether a simple mistake, simple negligence is reckless and wrong. And I would argue to you, members of the jury, that it is here today. She should not have forgotten about that child. She spent all that time with that child. Defense points out, well, I can't believe we showed you the video. Yeah, we showed you the video because that Tracy Nix that was at People Brady's should have been the Tracy Nix that got out of the car, but it wasn't. She was more focused on other stuff she wanted to do when she got home that she completely forgot about her. Not for 15 minutes, not for a half hour, not for 45 minutes, not for an hour, not for 90 minutes, not for 120 minutes, for almost 3 hours. Is that something a reasonable caregiver would do? Or is that something that's gross and flagrant and wanton and reckless? The act of leaving the child in the car, I don't think anyone would argue. If she, again, like I said, if she intended to leave that kid in that car and Yuri was trapped in there, she would be charged with a very different crime. We're talking about, it can be confusing, we're talking about negligence. She doesn't have to have the intent to hurt Yuri, but her actions did anyway. That's what we have to look at. It's a difficult case, members. It's a difficult crime. It's a difficult law. It is. But the facts are there. And once again, I need to remind you, she is not stepping on someone's foot. She is not leaving your eggs in the car overnight. She is a child. Defense counsel keyed in on a word, and there is a word in the culpable negligence instruction, conscious, and that throws people off. Conscious as opposed to unconscious. That's what that is. She was conscious the entire time. She should have known. She should not have forgotten. She had no reason to forget other than there were things more important, like playing the piano, taking care of the dog, feeding the pigs, finding her husband, those types of things. And defense counsel wants to talk about distractions. Well, from what we saw at Beefle Brady's, she deals well with distractions. There were a lot of distractions around her. Everyone came up to see that. But she didn't forget Yuri then. She didn't forget that. She took care of her. She did everything she was supposed to do. Unfortunately, Beefle Brady's Tracy Nix stayed there. What came home was the one who committed criminal negligence. At the end of the day, members of the jury, I think you have to look at all the facts and circumstances, not just the forgetting, but all of the surrounding circumstances. And you have to look at that and say, what would a reasonable person in that situation do? What would a reasonable person who is responsible for the care and safety of a 7-month-old infant do? And I would argue to you, it would be remember. Don't forget. Don't leave. Be focused on her. Make sure she's okay. She's your little granddaughter. Care for her, protect her, get her out of the car. And a failure to do that, members of the jury, that's a mistake, that's criminal. That's a mistake, that's culpable. That's a mistake, that's the crime of aggravated manslaughter. That's the mistake that she needs to be held accountable for under the law. And you need to go back in that jury room and convict her. Thank you.
Thank you. Do you want to close your screen down?
Yes, sir.
Please. All right, members of the jury, I want to thank you for your attention during this trial. Please pay attention to instructions.
Everything this judge saying, I say I ditto.
Instructions. Please go ahead and do that. Now, clerk, move that. You'll be able to take these instructions to the jury room with you. You'll have a verdict form. You'll also have information with the appropriate information. Statement of the charge. Tracy Howard Nix, the defendant in this case, has been accused of aggravated manslaughter of a child and leaving a child in a motor vehicle in excess of 15 minutes, causing great bodily harm. You'll have an information that shows the charges and the statutes. I won't read it to you because y'all all can read it when you get back there. That's fine right now. We'll be fine with just what we have. Aggravated manslaughter.
Okay, so let me be quiet.
To prove the crime of aggravated manslaughter, the state must prove the following 3 elements beyond a reasonable doubt. Uriel Jane Schott is dead. The death of Uriel Jane Schott was caused by the culpable negligence of Tracy Howard Nix. Uriel Jane Schott was at the time a child, and Uriel Jane
Welcome
Schott's
back to
death
Wobble.
was caused by the neglect of Tracy Howard Nix, a caregiver for Uriel Jane Schott. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life and of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. The defendant cannot be guilty of aggravated manslaughter if the killing was either justifiable or excusable homicide. I'm not going to instruct on that because we do not have that here. I'm going to tell you to exclude that off of these instructions. Child means any person under the age of 18 years. Caregiver means a parent, adult household member, or any other person responsible for a child's welfare. Neglect of a child means a caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain a child's physical and mental health, including but not limited to food, nutrition, clothing, shelter, supervision, medicine, and medical services that a prudent
Welcome back,
person
Lady
would
Steph.
consider essential for the well-being of the child. Neglect may be based on repeated conduct or on a single incident or omission by a caregiver that results in or could reasonably be expected to result in serious physical or psychological or mental injury or a substantial risk of death to the child. Leaving a child unattended or unsupervised in a motor vehicle causing great bodily harm. To prove the crime of leaving a child unattended or unsupervised in a motor vehicle causing great bodily harm, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Tracy Nix was a person responsible for Uriel Jane Shock. Number 2, Uriel Jane Shock was younger than 6 years of age. Number 3, Tracy Howard Nix left Uriel Jane Shock unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes or for any period of time if the health of the child was in danger. 4, in doing so, Tracy Howard Nix caused great bodily harm to Uriel Jane Shock. Motor vehicle means a self-propelled vehicle not operated upon rails or guideway, but not a bicycle, electric bicycle, motorized scooter, electric personal assistive mobility device, mobile carrier, personal device, swamp buggy, or moped. Vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. When there are lesser included crimes or attempt, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of a lesser included crime. The lesser included crimes indicated in the definition of aggravated manslaughter of a child is manslaughter. The lesser crimes included in the definition of leaving a child in a motor vehicle in excess of 15 minutes causing great bodily harm is leaving a child in a motor vehicle in excess of 15 minutes. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Uriel Jane Shock is dead. And number 2, the death of Uriel Jane Shock was caused by the culpable negligence of Tracy Howard Nix. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant.
Hey,
had an
Kathy,
intent
thank
to
you for
cause
supporting.
death, only an intent to commit an act that was not merely negligent and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violence is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. Leaving a child unattended or unsupervised in a motor vehicle. To prove the crime of leaving a child unattended or unsupervised in a motor vehicle causing great bodily harm, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Tracy Howard Nix was a person responsible for Uriel Jane Shock. Number 2, Uriel Jane Shock was a child younger than 6 years of age. And number 3, Tracy Howard Nix left Uriel Jane Shock unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes or for any period of time if the health of the child was in danger. Motor vehicle means a self-propelled vehicle not operated upon rails or guideway. Vehicle means every device in, upon, or which by any person or property is or may be transported or drawn upon a highway. Plead not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Throughout your deliberations, you may discuss with each other the evidence and the law that has been presented in the case, but you must not communicate with anyone else by any means about the case. You also cannot learn from outside sources about the case, the matters in the case, the legal issues in the case, or individuals or other entities involved in the case. This means that you may not use any electronic devices or social media such as a phone, computer, or tablet, the internet, any text or instant messaging, or any social media apps such as Twitter, Facebook, Instagram, LinkedIn, YouTube, WhatsApp, and Snapchat to research or communicate about what you've seen and heard in this courtroom. These restrictions continue during deliberations because it's essential under our Constitution that you decide the case based solely on the evidence and law presented in this courtroom. Information that you find on the internet or through social media might be incomplete, misleading, or inaccurate. And as I noted in my instructions at the start of the trial, even using your smartphone, tablets, and computers and news media and social media apps on those devices may inadvertently expose you to certain notices, such as pop-ups or advertisements that could influence your consideration of the matters you've heard about in this courtroom. You are permitted to discuss the case only with your fellow jurors during deliberations because they have seen and heard the same evidence and instructions on the law that you have. And it is important that you decide the case solely on the evidence presented during the trial without undue influence by anything or anyone outside the courtroom. For this reason, I expect you to inform me at the earliest opportunity should you learn about or share any information about this case outside of the courtroom or the jury room, or learn that another juror has done so. You will weigh the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number one, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the testimony and other evidence in the case? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed with law enforcement does not mean that his or her testimony should be given any other weight than any other testimony. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant did not testify in this matter. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in this case. The defendant's statements were introduced into evidence. A statement claimed to have been made by the defendant outside of court has been introduced into evidence. Such a statement should always be considered with caution and be weighed with great care to make sure it was freely and voluntarily made. If you conclude the defendant made the statement, you must also determine from the evidence whether this defendant's statement was freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to, one, whether when the defendant made the statement, they have been threatened to get them to make the statement. Two, whether anyone had promised the defendant anything to get the defendant to make the statement. If you conclude the defendant's made the out-of-court statement, but it was not freely and voluntarily made, you should disregard it. Rules for deliberation. There are some general rules that apply for your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. I've read them to you. You're going to get them, take them in the back. If you fail to follow the law, the verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have learned, that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job, my job, to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions that I'm giving you and that I've read to you. That is the law. I'm going to caution y'all. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I prefer one verdict over another. When you reach a verdict, you may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It reads as follows. It's 2 pages. The first page is the count 1 and 2, and the second page is where the foreperson dates and signs it. It says, in the Circuit Court, 10th Judicial Circuit of Florida, NN4, Hardy County, State of Florida versus Tracy Howard Nix, CF 22-289A, verdict form. We, the jury, find as follows as to count 1 of the charge. Check only 1. You check 1. The defendant, Tracy Howard Nix, is guilty of aggravated manslaughter of a child, or the defendant, Tracy Howard Nix, is guilty of manslaughter, a lesser included offense of count 1, or this defendant, Tracy Howard Nix, is not guilty. You go then to count 2. We, the jury, find as follows as to the count 2 of the charge. Check only 1. The defendant, Tracy Howard Nix, is guilty of leaving child in a motor vehicle in excess of 15 minutes, causing great bodily harm, or the defendant, Tracy Howard Nix, is guilty of leaving child in a motor vehicle in excess of 15 minutes, a lesser included offense of category 1, or the defendant, Tracy Howard Nix, is not guilty. You go to the second page, you date it, the foreperson. So we all say this blank day of January 2025, foreperson signs it, prints the name. A single defendant with multiple counts or information. A separate crime is charged in each count of the information, and although they have been tried together, each crime and evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. I'm going to submit the case to you as the jurors. We're going to have lunch. It's already been ordered for you. It'll be in there. You're going to have time. So in a few minutes, the bailiff's going to take you to that room. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried out in an organized way that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case until you have reached a verdict. You must talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I've given you in the case, you must tell me by giving a note to the bailiff. Many of you have cell phones, laptops, tablets, and other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of these types of electronic devices into the courtroom. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. Do take your notes.
Okay, so I wanted us to definitely hear the part about how to decide and the criteria for the different charges. Okay, so what we're faced with in this jury poll is going to be a little bit different. So let me type it in. Okay, so when we do the jury poll, we're going to have three options. I'm just going to put the three. Okay, so we're going to find not guilty of everything. Hold on, let me type it like this. 1, not guilty of all. 2, guilty of manslaughter. 3, guilty because they're leaving the child in the car is actually a charge. Okay, so I'm gonna put these on the screen, and we're gonna do a jury poll. You know, I know a lot of you guys are working or on the move. You know, so you may not be able to get your vote in, but you can definitely leave me a comment under this video of what you would have, what your verdict would have been if you're unable to right now. Oh my gosh, I don't want my. Okay, so where was I? I'm sorry. She don't normally call me, so I had to answer that call. Where was I? Oh, saying that if you're not able to put in your verdict now because you're in motion or not able to get to the computer, I definitely understand. Please do leave me a comment underneath this video. Come back to the live, but let me know what your verdict would have been. Okay, I'm very interested to know. But for you guys who are able to cast your verdict now or your vote for a verdict now, the charge, number 1, you're going to say not guilty of all, if that's your verdict. Number 2, you can decide guilty of manslaughter. That's one verdict. Or finally, you can cast your verdict of guilty of leaving child in the car. That's almost like a criminal negligence. Okay. No, I didn't. I should have put them in order. No. They're not in order of, I did not put these in order of severity. The most severe charge on here, thank you for that, Kathy. The most severe charge that she can be found guilty of that has the most criminal weight, consequence weight, is guilty of manslaughter. Okay. The lesser guilty charge would be the leaving the child in the car. Okay. Thank you for that. I should have put it maybe in order like that. So go ahead. Feel free to cast your verdict. Okay. And of course, this is a arena where, hey, you know, we're not having a discussion today to argue your point today. Feel free to say what you feel. You know, this is a non-judgment zone. And when we get to casting our final verdict, I will not be challenging nobody. Okay, I have a question for you. According to the court, what's the difference between manslaughter and leaving the child in the car? Manslaughter is like that's a hard question. Now, see, I just let that man talk. I know one thing. I don't know how to answer that directly. I should have wrote down how he said it. But, Lady Steph, what I can tell you is that leaving a child in the car is a lesser charge. Okay? Leaving a child in the car, thank you to Wobble, is no intent to harm. Thank you. Thank you. I should have wrote it down when he was saying, because that's the reason why I was listening. But it's hard for me to put it in words. Thank you to Wobble. Lady Steph, please refer to the Wobble. Thank you guys for joining me too for this content. We have been just pushing, and we have been very activated over here. So manslaughter is the intent to harm. Hey, Miss Steph 29, drop down. You heard me holler at you earlier in the clouds. I knew you was up there, girl. But yes, so while you guys, I'm gonna let you guys do. Let me put my verdict in. Oh, foot soldier. Foot soldier says that's crazy because there should have been a bigger charge as well. So you think that it should have been a more severe charge than manslaughter? Because a more severe charge than manslaughter would be like murder in the first degree or murder in the second degree. Okay, so the verdicts are coming in. Kervixen, what say you? Kervixen says 3. Murder by leaving the child in the car. Foot soldier, what say you? 2. Guilty of manslaughter. Ooh. Kathy Smith, what say you? 2. Guilty of manslaughter. And Renee, what say you? 3. Guilty of leaving a child in the car. So far we have, it's even. 2 leaving the car, 2 manslaughters. The Wobble, what say you? 3. Guilty of leaving the child in the car. B.A. Sage, what say you? You went with 3. Guilty of leaving the child in the car. Living 3. What say you? Guilty of leaving the child in the car. Lady Steph, what say you? 3. Guilty of leaving the child in the car. The Wobble, did you vote already? Okay, Miss Steph 219, I'm waiting on, I don't think I see your verdict. And Lady Steph, no, but you voted already. But if manslaughter is intentionally wanting to harm the child, I don't think it could be manslaughter. I don't think that she felt, I don't feel that she said, I'm going to leave the child in this car to go in the house. Right. I don't either. Foot soldier says, we waiting on Miss Steph 219. I know that she's busy, so I'm going to give her opportunity to put her verdict. Winter says 3, guilty of leaving the child in the car. Did I type mine in? I did. Trial watch with Demetri. What say I? I say 3, guilty of leaving the child in the car. So it looks like we have, let me make sure though. Yeah, manslaughter is intentional. So we got 1, 2, 3, 4, 5, 6. Oh, okay. No, Miss Steph 219 said 2. I think she said 2. I got you, Miss Steph 219. Okay, so Miss Steph 129. Miss Steph 219, that was her verdict. What say you, Miss Steph 219? And she says 2. Guilty by way of manslaughter. I'm pretty sure you're saying 2. Okay, I got you. I had to figure that out. So, okay, let me start over there. Okay, so that's 1. And because of our jury, because we definitely have voted 3. The overwhelming verdicts come through. The consensus is 3. Guilty of the lesser charge of leaving the child in the car. Okay, but she had, it was quite a few. Not to be unsaid, it was quite a few guilty by manslaughters. So, hey, she walking a thin line. If our jury has anything to say with it. So we're going to go ahead, but the magic of YouTube, the Lit Lane jury, let me put that as a banner. One moment. Well, so do you pick 2? You pick, I thought you picked 2. I could have sworn you picked 2, which was the harder case right here. Guilty of manslaughter. So that would have her doing some hard time. Well, either way it go, y'all do realize that she's going to get some type of time regardless of which guilty it is, but because of her status in the community, because of the fact that she probably doesn't have any, I'm assuming, no other previous criminal record, I doubt very seriously, and I'm going to have to put it down on my calendar to just really watch, just keep an eye on this. I doubt she even does a year in jail or prison. They could even sentence her to, let's say, 2-3 years of prison time. And the judge could actually waive her time, suspend the time where she never has to go in and make it probation. He has a lot of leeway. Let me put this in. Okay, okay. This is why the defense felt so harmful not to women. This is the defense fault. This is the defense fault. So harm not to have the death of the first child admitted into the testimony. Oh, this is why the defense fought so hard. Baby, I was having a hard time. Thank you. This is why the defense fought so hard to not have the death of the first child admitted into the testimony. Absolutely. And guess what? That might be the best thing that the defense did, because the defense gave a horrible closing argument. I want to make sure I talk about that. Sorry, I'm typing in y'all ear. Right, this was our second time. I feel like had they entered in the previous child death, oh my God, she would be guilty of manslaughter so fast, make your head spin. So I'm posting the Lit Lane verdict, guilty of a lesser charge of leaving the child in the car. They have come to a verdict. It looks like they came to a verdict in about 2 hours. It seemed like they took no more than 3 hours to come to their verdict. Again, this was a 2-day trial. Oh, already doing the okay, they say jurors now deliberating.
You on TV, on live stream on TV today that was done.
Who's this man up here?
Raise your right hand.
Oh, they doing-
Swear or affirm the testimony given in this case be the truth, the whole truth, nothing but the truth, so help you God? Okay, you can step back, you need to step back.
Maybe he picked the wrong day to go to court. Now everybody see him.
I just,
Whatever's more comfortable for him.
I'd assume he'd just be back a little bit.
Sir, and I apologize.
What he done?
Eugene Perry.
Okay, you're the cameraman that was manning the camera.
Yes.
Okay, go ahead, Mr. Fletcher, and if there's an inappropriate question, state can object, or I'll
Is this a jury?
question. All right, go ahead.
You were the cameraman during the closing argument?
Yes.
All right. Did you, for whatever accidentally or intentionally, view the jury on the camera?
Objection,
don't know.
compound.
I don't know. If I did, it was a flash of me moving from one shot to another one.
Oh,
I've
Lord.
never just sat on the jury. So if I have a shot on my video.
I didn't see no jury, but we might not be watching his camera.
Actually moving to somewhere
Is it,
across maybe, but
is it difficult?
I didn't.
Oh, Lord.
Thank you. Thank you, sir.
All right, state anything further.
Oh, Lord. Brother man then sat there and now they accusing him. They could have almost had a mistrial. And I was gonna say we didn't see the jury, but he might have been media from a different source, obviously, right? The defense put on a horrible case. That's what VA Sage said. Put so to say, I say this all the time. The laws are made for the criminals. Absolutely. Winter said, well, unless it's swinging or unless it's swing against your favor. Winter says there was really nothing else for the defense to say in closing. Well, it's not about what he said when, like in what he said, the defense, true. He didn't have too much more to say. But the reason Demetra says he gave a horrible closing, what make me say it was horrible is that his verbiage, he was very, very much so minimizing. I feel like everything, the point that he was trying to make, yes. How he made it, horrible. Like comparing to groceries left in the car, his verbiage, oh my God, it was very almost offensive to me when we thinking about the fact that it was actually a child left in the car. It wasn't groceries. It wasn't you just forgot to go pick a friend up. It was an actual baby that you left in the car and that died. So to me, his verbiage sucked. And then it left the door wide open for the state to come in on rebuttal closing and do exactly what they said, which was to point out how sucky his verbiage was, okay, for lack of a better way to put it, okay. But yeah, I absolutely agree. He didn't have much room. All he could do was point out the fact that it wasn't no malice and that it was just a mistake. That's all he could do. But yet again, in favor for to say one good thing for the defense, the best thing the defense did this whole trial, in my opinion, was getting that first offense, that first situation of having that first baby, that grandbaby that drowned Ezra. When the defense fought and successfully got that omitted from this trial, that was getting their money worth. Okay? If he didn't do nothing else, whatever they paid him for, that he got the job done. Period. If you want to say that she just really not sorry, like I saw some people say that she just really embarrassed, having that omitted, right? Helped her in that. It helped her from facing real. Yes, he did a good job in getting that omitted. Okay, who is these people?
Butcher, the courtroom is yours.
Thank you.
Wait a minute, did I miss the verdict? Who is all these people? Why they deliberate?
Not only when a product gets approved by the FDA, does the manufacturer have to disclose for a special.
I don't know what all this is.
Work time was working for another school. Publications that are specific.
extra stuff.
with neurologic status, cognitive status, behavioral changes that take place. So these are neurologic complications. In the body,
Yeah.
a medical doctor was a PA, doubled the dose to a dose that was twice what was recommended for elderly individuals.
Wait a
when a
minute.
person is forgotten, when a child is forgotten.
Oh, wait a minute. Wait.
since the early 90s.
Wait. Maybe all that is arguments for the thing. What's confusing me is they keep having that ticker at the bottom that say the jury is deliberating, but he had to have given the verdict. Let me see. Sorry, y'all. I'm confused. Let me see.
Okay.
Did you want to read it further? I'm going to put it in the record and I'm going to talk to you about it. All right, first juror question is, can we have further explanation as to the definition of gross and flagrant?
Oh, this different.
State what's your position.
Your Honor, I know in these situations whenever they're asking for clarification on the law, often the court decides to advise them that they've received all the laws and the applicable definitions of the terms in those laws, and that apply to this case in the jury instructions. I guess that would really apply to both. I would argue that the difference between aggravated manslaughter and manslaughter is kind of clear. It's either a child or it's not, but again, I can see the court relying upon that standard answer of you've received all applicable laws and instructions in this case.
All right, defense.
Obviously, the jury's confused. That's my concern. I don't think gross is actually defined in the jury instructions or aggravated.
Okay.
Which creates a problem. I don't know. Candidly, I don't want to see a confused jury.
All right, go ahead.
I don't have any definitions of gross or aggravated off the top of my head.
I'm going to tell the jury on that, all applicable law and definitions that apply are in the jury instructions.
Well, damn, the judge gonna go send back a note to them to read the instructions again. Huh? Okay. So the jury's having a hard time back there.
Please read again.
He just said exactly what I said. Please read again.
All right, second one. What is the difference between aggravated manslaughter and manslaughter? State.
Your Honor, I believe the court has a choice. It can either rely upon, like I said in the earlier statement, or there are elements, and the elements are kind of pretty clear. And according to my memory of those elements, the only difference between aggravated manslaughter and manslaughter is a child. That's what makes it aggravated.
Correct. Defense, what's your position?
I think it's explained in the jury instructions.
Oh, wow. So that was really good. So he said, I mean, I know y'all heard him, but I'm repeating it. He said the only difference between aggravated and manslaughter is a child. And I think the aggravated is the one with the child because it's even more horrendous, right? Let's see. Wow. It's different.
All right, I'll say the same answer for number 2. Okay. All right, let's bring the jury in. Jury's coming in.
I think it kind of sucks that the judge is simply finna tell him to read it again, right? There, why not? I mean, I guess because he has to stay. I've seen it where the judge is like, okay, this is what I have to give you. This is what I'm allowed to tell you. I think it must be that. It seems kind of real harsh that obviously they have read the instructions. Obviously, with having read the instructions and being a layman, not a legal expert, they're having a hard time, obviously, understanding the jury charge, the instructions. They want it to be broken down probably in layman's terms. And I just don't think the judge can do that. Lady Steph says, How dare you have the jurors come to you, and because you don't know the answers, you tell them to reread the instructions. I think the judge knows the answers, but I think he can't put it like in layman's terms. Let's see what he tell them. Let's see. Boy, this just got more interesting real fast, huh? I like when they throw us a curveball. Lady Steph, is that what you wanted to tell me, child? When I say I don't know. Well, there's that. Lady Steph say, well, then don't have laymen come out and decide the trial. There's always that.
Thank you.
All rise.
I can hear your scream in your type, okay?
Maybe seated. All right, members of the defense and the state, make sure the clerk has your cell phone numbers, because if we have one question, we may have more. I'll be in my chambers. We can come back at any time if I need everybody around. I do know we're gonna start in 15 minutes with the proffer, so if you want to start early, we can start now.
I'd like to maybe start a few minutes later since we got tied up. I was in the middle of doing that when I got called.
Okay, well, we're gonna start that at 1. Okay. All right. Thank you. I'll be back at 1. All right.
So apparently they must be like cutting out some parts, because he just said bring the jury in.
All rise, please.
It's so weird. They had to have been cutting out some parts or something. I don't know what's happening. Let me just be quiet. Where he going? Child, I'm confused. I'm confused. I could have sworn he said let's bring the jury in, didn't he? Now, I don't know what they finna do right here with these other people taking the stand, but we're going to just be patient and find out.
Respected, so.
Okay, let me rewind it to when the judge come in now. Okay, here go the judge.
Let me go on the record of the just so the cameraman knows, when the jurors are coming in and out, that's not recorded at all. Okay?
Well, what happened, Your Honor, was I wasn't in here on the camera.
Okay.
I just got the camera on and that was unexpected, so when I walked in, they were here and then I just turned it away.
No problem. All right, just make sure we don't have that anymore. Okay. And now we're here, so we're off the official record. However, now Mr. Fletcher's going to do his proffer. So, Mr. Fletcher, the courtroom is yours. Thank you, Your Honor. I call Dr. Benson. You do record this, but it's not, I'm just here. Right here.
Please make your right hand. Do you solemnly swear or affirm to defend the whole truth and nothing but the truth, so help you God?
I'm going to Google what is a proffer.
The state's not going to cross-examine. They're not, this is a new trial, so I just want to make sure that's clear on the
Yeah,
record.
the record's clear. You and I are just both sitting here. I'm doing some other work and you're doing whatever you're doing.
Thank you.
Go ahead.
Thank you, Your Honor. State your name, please.
Dr. Daniel E. Buffington, Buffington.
Okay. Have you ever testified in court?
Yes, sir.
Okay. Approximately how many times?
Oh, since the early 90s, probably now in excess of 500.
All right, before we get started with the defense proffer. So I Googled and it says a proffer in court refers to the act of formally offering evidence to the judge, usually in the form of an attorney stating what the evidence would show if it were allowed to be presented, without actually introducing the evidence itself. Essentially, it's an offer of proof used to preserve an issue for appeal. Oh, this is being done for appeal purposes. If the court denies the evidence admission. Key points about a proffer. Used to preserve rights. If a judge rules against admitting certain evidence, a lawyer can proffer what that evidence would have shown to create a record for the potential appeal. Okay, so it's very interesting. So a proffer, they have not done a verdict. The jury is still deliberating. The jury sent out 2 questions. They seem not to understand the difference between like aggravated and manslaughter and regular manslaughter. The judge did not offer any type of breakdown on the 2. He simply sent the instructions for the jury to reread. It's not, no, it's proffer. 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 What is what is proffer during a trial is how you would Google it. So what I find very interesting, number one, just to make it plain, a proffer is when they go ahead and offer in and put on record evidence that was not allowed in. Exactly, Lady Steph. And so the defense is finna is right now about to do a proffer. Yes. Now, this is a sidebar. When we got 500 people up in here, I'm not going to be telling them 500 new people about my tooth. Okay? Now, as soon as we be having 50, 60 people up in here, we are not allowed to talk about the fact that I got one new tooth. Okay? Now, we is a tight-knit community right now. We are growing. Okay? No, don't try to cut me off from saying nothing. I'm going to give my speech about this tooth. Okay? Now, I'm going to say this. Let's make it official. Starting February of 2025, we is not allowed to make any reference to my tooth. I'm going to make sure I got it in. I'm not going to say nothing about it. And y'all not going to say nothing about it. But that starts in February 2025. The court has made its ruling. I need a gavel. Okay? Boom. Okay. Right now, back to the matter at hand. The defense, what I find interesting is that the defense oh my God. Let me readjust my tooth. Hold on. Okay. Hold on. It is a little loose. I only had 1 cup of coffee, but look, y'all gonna let me get this out because we never seen this before. Proper, but see, he's not saying proper. He's saying proper. Yeah, see, Winter been made a cold word. The love seat. Okay. But I am getting back to the point. Y'all are all off track. Okay. Thank you very much. Who is that? Lady Steph. No, Living. I thought that was Lady Steph being funny with me. I might have to think about getting some new bathers. No, I'm kidding. But for real. The word is actually proffer, not proper. It's proffer, right? So we read Google. Google let us know that what that means is, in this case, the defense is putting up these witnesses and whatever they finna tell us and we're going to listen to outside of the jury, and also the judge not paying no attention. And that's because the judge has already decided whatever we finna hear would not be allowed in the trial. However, the defense still wants this information, this testimony we're going to hear. The defense still wants it to be part of the court records. And according to Google, that's because they want it part of the records. So if they have to do an appeal, it'll be there. Okay. So we finna hear testimony that this judge did not let in, but the defense wants a part of the record. Now, what I find very interesting is that the defense is doing this. Because according to what we just found out from Google, a proffer is, I would have thought that if anybody was doing a proffer, it would have been the state. And that's because I would have thought that the state would want it on some type of record about the first baby's accidental death under this lady's care. So I found that very interesting that we hearing this type of stuff from the defense. But let's get into it. Okay, we're seeing something interesting. We're seeing something different. Let's go.
Okay. And what's your specialty?
Clinical pharmacology and toxicology.
Okay. Have you ever been, I assume you've been qualified in court in those fields of expertise more than 500 times?
Yes, sir.
Okay. Can you give us your education, training, and background?
Yes, sir. I did my undergraduate studies in biology and biochemistry at the University of South Florida, a native of the Tampa Bay area. Following that, I did a Doctor of Pharmacy degree, or PharmD, at Mercer University in Atlanta. After that, did postgraduate specialization at Emory University in residency and fellowship in clinical pharmacology and tox. And then after that, also completed an MBA with a healthcare focus from Mercer.
And have you reviewed the case records and interviewed Tracy Nix?
Yes, sir, I did.
In this case? Okay. Do you have any particular methods that you'd like to tell us about as far as what you did and what you used?
Yes, sir. So similar to a clinical evaluation with a patient in any inpatient or outpatient setting, my goal was to go through a variety of records that would be beneficial to understand her history, medical, medication, family and social history, laboratory results and data, any prior hospital and clinic records that would help to identify and support an understanding of what medications she was on, pharmacy records, helping to confirm exactly what substances in terms of medication she was taking around this time.
Okay. And can you tell us what all you reviewed?
So I reviewed hospital and clinic records. I reviewed law enforcement records from this particular case. It also included a clinical interview with Ms. Nix as well to have a better understanding of what was happening in her life and any symptoms that may have been consistent with the adverse side effects of the medications that she was being prescribed.
Okay. Anything else that you reviewed in this case?
Yes. So in addition to my training and understanding, it's imperative to stay current in the medical literature. So I did look at medical literature surrounding these particular medications. That can come from a variety of clinical trial data. It can come from FDA approved materials that a manufacturer is required to organize and make public to healthcare practitioners to understand the therapeutic benefits, but also the adverse side effect profiles and risks for medications. There's a variety of other databases that we use in clinical practice. We call them pharmacovigilance, and that is where we not only when a product gets approved by the FDA does the manufacturer have to disclose for a specialty panel to understand, to approve that product for use in the United States. That type of tracking goes on for years. So we have MedWatch, we have the FARS database, we have multiple established database systems that healthcare practitioners contribute to even after a product is approved and in the market. And in many cases, we find more out after a product is out in use in large number of patients than we did even at the time a product was approved. So there's also a series of drug interaction databases where if I'm sitting down in a clinic or if I'm doing a forensic review, I can put the patient's medication profile into that data set and then identify if there are in fact drug-drug interactions, meaning one drug competes with another, one drug causes a complication in another. And to a great extent, what we know now is all of us in this room may metabolize the same drug differently. That could be that you don't get as much effect versus the other person. It could be that you get a dramatically higher effect than the other person. So I went through each of those tools that I use in my own clinical practice setting to review this case.
Okay. Anything else other than what you indicated that you reviewed?
I think that's comprehensive. Yes, sir.
Comprehensive?
Yes.
Okay. And did you review case-related depositions?
Yes, sir.
And you already indicated police reports?
Yes, sir.
And some transcripts?
Correct.
And text messages?
Yes, sir.
And photographs?
Yes, sir.
Okay. Did you render a specialty opinion within your education, training, and experience as to the origin and cause of any issues that Tracy Nix may have had with regard to any altered cognitive status at the time of this event on November 1st, 2022?
Yes, sir, I did.
And could you tell us, please, what your findings were?
Yes, sir. The findings are that the collective list of medications that I confirmed by medical and pharmacy records gave me a clear indication of what she was being prescribed simultaneously during that time.
Okay.
The symptoms that she was experiencing, as based on the interview and based on her statements, are consistent with the adverse side effects with regards to cognitive status, confusion, attention deficits that come with those medications. And,
Okay.
and in fact, there were multiple combined reasons for concern or interactions between the medications she was prescribed.
Okay. Did you identify any significant variables in her past medical history that factored into your findings?
Yes, sir.
And could you tell us about that?
So specifically when looking at her case is in patients 60 and 65 and older, we use significant caution when introducing or prescribing certain medications. In fact, we even maintain a national list or registry of those products called the Beers list. That's named after Dr. Beers. And in that, she was on multiple medications that would be of high concern or risk factor for these types of side effects that are recognized in the Beers list, as well as in the FDA-approved packaged materials and the other patient safety databases as well.
And well, these were actually the medications you're talking about were all prescribed to her?
That is correct.
And you know who did the prescribing?
I have it in my notes, but I didn't take the practitioner's name to memory.
Okay. Did you identify any significant variables in her past social, family, and work history that factored in your findings?
Yes, sir.
And could you tell us about that?
So in addition to her age and history of insomnia and depression, fibromyalgia and sleep apnea, things that she was being treated for, I also identified that she had a family member, a brother, a sibling, who was also experiencing, going through symptoms of early onset dementia, which would have been concerned. She expressed concern that she may attribute some of what she was feeling or experiencing with confusion or mental clouding as being something familial that was happening. There was also work-related examples. She was previously in a leadership position in a school, had transitioned from that based on age and duration of work time, was working for another school. In that situation during this time, she expressed that she, as well as her supervisor, were noticing difficulty for her to identify and retain attention and completion of tasks, again, consistent with the types of symptoms that these medications, when used, can cause.
Did you identify any significant variables in her past sleep-related disorder history that factored into your findings?
Yes, sir. Combination of insomnia and sleep apnea. Both are disruptive disorders to getting what we call restorative sleep. That impacts someone during your sleep. In fact, some of the medications she's on actually are prescribed or used to help with sleep, but they can cause what we call complex sleep-related disorders or behaviors. And that's where the risk is in a percentage of patients, you're giving it to help them sleep, but it may actually cause abnormal behaviors, thought processes, or disrupted sleep. And that can be something that occurs during the night or during a period that the individual is sleeping, whether it's night or day. Or it can also be what we refer to as next day cognitive decline or next day drowsiness, where the individual isn't as sharp. And it's not just that they aren't trying to get enough sleep. It's not just that they aren't taking care of themselves. It's something that these particular medications induce on a person and actually worsen the quality of sleep and cause mental clouding and confusion the next day, even after they've been up.
And what drugs are we talking about?
So those in particular are Ambien and cyclobenzaprine and also lorazepam. So there's each of those represent a different class of medications, but each of those carry with them significant concerns and warnings over the ability to produce these types of changes in cognitive status, clarity, attention, and thought process.
Are any of these medications on the Beers list?
Yes, sir. Each of those.
All of them are?
I would have to double check for the cyclo, but I'm pretty sure it is as well. But the benzodiazepines and the zolpidem, that's the generic name for Ambien, is clearly on that list. It's so much on the list that the FDA requires the manufacturers to disclose, makes it a substantial warning, and has even in recent years said it has to be disclosed to patients when they're doing direct-to-consumer advertising. So that means that it's not just something that only a few people should be warned of. It's something that everyone should be warned of.
Let's look at Ambien.
Excuse me, just a sidebar. I've seen actually whereas people have gotten under the influence, right? Because of Ambien, right? Like if you take it and go out and drive, they'll give you a ticket for being under the influence. So not saying she took it before she left the house, but even like having taken it at nighttime, but then you find yourself having to get up earlier than you expected or would have thought, and then you still be under the influence of it. Just saying, just a thought. I wonder why they didn't let this testimony in.
As a pharmacologist and a toxicologist, would you recommend that Ambien be given to a patient 65 years of age on a long-term basis?
Absolutely not. It would be for short-term use in an acute emotional scenario where the insomnia has occurred abruptly. It is not going to be safe to use long-term. And in fact, there are alternatives that would make it not even desirable in my practice setting to recommend it to someone 65 and older. In fact, the incidence that I see those types of side effects and problems is high even in patients under 65. It's not a product that I recommend.
Okay. And what about, I'm going to use a trade name, Flexeril?
Yes, Flexeril is a muscle relaxer. So Ambien or zolpidem was a medication used to help induce and keep you to get a sound, restful sleep when it's doing its job right. Flexeril is something that actually relaxes a person if they're having muscle spasms, if they're having fibromyalgia. That's the times it's reached for as a therapeutic tool. Many patients have to discontinue that product because they have cognitive status changes. They have balance changes, normally able to traverse, walk safely. Next thing you know, we're identifying they're stumbling, they're falling, they're feeling dizzy, confused. So it's a medication that, again, it's been around a long time, but it's got limited use and should not be used in patients 60 and older.
Lorazepam.
Lorazepam's yet another therapeutic class. It's in the benzodiazepines, so like Valium and Xanax and others. It is a medication that has many uses, but many of them are because of its side effects. So it is a muscle relaxant and something that can sedate someone. So in that case, some prescribers may suggest it for sleep. The problem is it can also cause extended next day drowsiness. So it's not optimal. It's not optimal in an older patient. It's also something that can cause hallucinations, anxiety, even though it's something that can treat anxiety. So it's a medication with many different effects on the human body and the brain, but would not be recommended for someone who's having confusion or attention issues.
Okay. What about a person 65 years of age or older?
No, sir, it would not be recommended, and certainly not for long-term use as a sleep aid.
Okay. What about the combination of these medications? Would that be appropriate to prescribe that on behalf of a patient, all three of these in combination with each other?
No, sir. Given the circumstance of her unique patient profile, of her as a person, as an age, as medical conditions, it would not be recommended. So this was not an optimal drug regimen profile for her. The other issue is that it would not be recommended based on the fact that each of these can cause lingering, enhanced complications that are not helpful for the patient.
With respect to the Zolpidem, also known as Ambien, did you determine that she was on an appropriate dosage of that?
Given her age and size, that is actually a large dose. So again, if you dive deeper into the analysis of her medication regimen, it wasn't even like a starting dose. It wasn't an introductory dose. It was actually a substantially large dose, and that would not be recommended. In addition, I looked at the combination of medications and for drug interactions, and there were numerous drug interactions between the medications she was on.
Do you consider it to be malpractice for a practitioner to prescribe these three medications, including Zolpidem, in the amount that it was prescribed?
In this particular case, I would express significant concerns combined with the fact that was there a monitoring program in place to identify those? And in the review of the records, I didn't see that. These look like medications that have been put on, doses increased, and then left in place. And I saw that throughout 21 and 2022.
Okay. Other than what you testified to, have you identified any significant variables in her past memory and recall history that factored into your findings?
Well, her own testimony of what had been changing at a workplace setting, she also identified that there were times when driving on daily tasks that she had gotten lost in areas that she was previously familiar with. So whether or not this was an element of an onset or development of dementia type symptoms, or whether it was dementia related activities as a result of the medications, both of those would be a concern in her medical history.
Other than what you've already testified to, did you identify any significant variables in her past medical and hospital records that factored into your findings?
Just that, as I stated before, the presence of insomnia and sleep apnea would be even greater reasons for a prescriber to avoid these medications. Then there was the age, and then was looking at them in their totality, all of them together, and saying this is an okay regimen to stay on, was really overlooking the risk that was being induced.
And obviously you review the medical literature. Can you be specific?
Yes, sir. So first and foremost would be the FDA approved package insert on these medications. They specifically warn of these concerns. The Beers list is a industry-wide tracking tool. It specifically gives concerns and warns in her situation. And then in addition, the pharmacovigilance databases, the MedWatch, the FARS, also highlight those, and those are available to any healthcare practitioner to use as a clinical reference. All of these things demonstrate a consensus that individually, these medications and combined would be disadvantageous in her situation. And the symptoms that she expressed as concerns are directly consistent with those symptoms we would see.
Okay. Did you find support or consensus in the published research and medical literature to support your clinical findings and opinion?
Yes, sir, an abundance.
Okay. Can you be specific?
Yes, sir. The MedWatch, the package insert, the FARS data set, publications that are specific to individual medications and their drug interactions as classes. I have large sets of files for tracking and teaching these very points as well.
Can you tell us the opinions you reached after your review in this case?
Yes, sir. The opinion is that her collective medication profile at that time placed her at risk, and the adverse side effects that she was experiencing, noting, they even appeared in her medical record, is that after the lorazepam was added early in 2022, this occurred in November of 2022, that there was a development of symptoms consistent with and do appear to be have been caused by her collective adverse side effects from her drug regimen.
Okay. Make any other opinions in this case, sir?
I think that's it.
All right. I'm gonna. Sorry not to be formal and ask to approach the witness, but I guess I don't need to do that.
It's your courtroom. I'm just.
It's my courtroom.
I may get up and
Yes, sir.
come back. You never know.
All right.
Your courtroom.
Thank you. Can you tell us what that is?
Yes, sir. So this would have been part of those methods. So when I sit down with a patient in an exam room, in a hospital room, in a clinic, anywhere, this exercise is the same. I start off by looking at what their baseline conditions are that need treated. Then looking at what has been previously prescribed as therapy versus what's currently medication profile. Most of that is, the objective is to discern, are they on the right medications to treat their conditions? One of the next steps as a specialist is to actually go a layer deeper and say, are the medications that the individual is on, looking at them individually, but then looking at them collectively, have the potential to create problems? The number one healthcare tool and treatment modality in the United States is medications. More than surgeries, more than anything else. The number one healthcare related harm, meaning you go for treatment and you have complications, is adverse drug events. So the two of those go hand in hand. This table that I prepared demonstrates on the left column the list of medications that she was on collectively.
Okay.
Across the top are adverse side effects that are consistent with neurologic status, cognitive status, behavioral changes that take place. So these are neurologic complications. In the boxes across the table, anywhere there's a red X, that drug carries with it the risk of producing that side effect.
Okay.
So I refer to this as, once we've looked at, are you on the right drugs? I'm now looking at, are there problems by combining, prescribing any one of them or combining, that may be contributing to your baseline symptoms or now new symptoms. So in this case, we call this the side effect burden, meaning not one, but multiples of these medications are all causing extremely similar adverse side effects. So it's synergistic, meaning just like we want to say we're treating the core issue while you got the prescription, we're also now collectively creating a more dangerous scenario for the patient.
Okay. Is there a way you can go through and tell us the drug she was on and the reactions as per that table?
Yes, sir. So the first drug and greatest concern is Zolpidem or Ambien. And in fact, it's the sustained release, and she was on extremely large dose, bigger than a dose that I would anticipate taking. So you can have CNS depression or mental symptom depression. You can have complex sleep-related behaviors. That's where an individual goes into a REM cycle and it's not normal. It actually sleep walking, sleep talking, sleep driving, sleep doing other things that they're not cognitively in command of. So abnormal thoughts and behaviors, physical behaviors at the same time. They could have cognitive dysfunction or confusion, disorientation, amnesia, hallucinations, delirium, depression, drowsiness, a whole host. Then if you go to the next drug, cyclobenzaprine, very different product. This one's used for muscle relaxing. And in fact, it carries with it most of those same adverse side effects as a potential complication. Even her meloxicam, we didn't mention that earlier. The brand name of that is Mobic. That would be like an advanced version more potent version of an ibuprofen or a naproxen. And you say, well, clearly that's an anti-inflammatory. That would not have any central nervous system adverse side effects. I'll challenge you to look at the literature. It has adverse side effects because of the changes in cells and receptors in the brain at the same time. It has a different function, but it carries with it side effects, not as many. Cymbalta or duloxetine was her antidepressant. It has many of these same. And then adding the Ativan is probably worse than the ones above individually, but now it's created a compound effect for mental status change and cognitive decline.
Okay. All right. Any other opinions that you formed in this case that we haven't talked about?
I think that's it.
Okay. Thanks, sir.
Thank you. I'm done.
Since it's my court, you're excused.
Thank you.
Your Honor, I just, for clarity of the record, if the public comes around and looks at this, I do want to make sure it's clear that the deposition the state took of Dr. Buffington October 30th of 2024 is attached to the motion that the state filed to exclude these witnesses November 26th of 2024.
That was my recollection. It was approximately 90 pages, 3 different depositions were attached.
Yes.
7-page motion, 83 pages of other.
Correct, Your Honor. I just want to make sure that's also on the record since we're just, I guess, putting stuff on the record here.
That's fine. You guys can do that. I mean, go back to my chambers for another matter. Sure. Going to call.
Okay, I'm back. So let's have this conversation, right? Let's have this conversation. So I asked in here, I said, what y'all think about the omission of both the previous death and also about this medicine and the complexities and the effect it may have had? So y'all really got activated. Went to say the prior act, and that's a good way to put it, the prior act in this medical situation are totally different. Correct, but it would have aided probably on both sides. You know, it would have helped the defense to talk about this stuff with the medicine. It would have helped the prosecution to admit the prior act. Lady Steph say, I think they failed, prosecution and defense by omitting. But the argument could be made that she was never convicted of the first child. So why bring it in? Concerning meds, that's current and ongoing. So, hey, you almost making the point. Okay, let me hurry up. If the prior act could be considered a reason for this current act directly, then that would be different. Okay. I said, I already said that part. Then I told y'all, great job for the perspectives. But the prior act is not considered, hold on, who was this man? But the prior act is not considered the cause or reason for this act. Very true. It's not, and it couldn't be the reason. Very true. The medicine or medical can be directly related to this act. Correct. Winter, I agree. I agree with you, Lady Steph. So with that being said, now that we know that this medicinal interaction, we know that was omitted for the defense. We know the prior act was omitted for the state. We just talked it out. Y'all hashed it out. Which one of those two, and then y'all seem to be typing it, but just tell me straight out. It looked like y'all saying, okay, even though, tell me if I'm wrong. Y'all saying, okay, the prior act with the grandson, it really didn't cause this next event, this second death. It didn't cause, it showed a pattern, a pattern, but it didn't cause it. But the medicine part may have very well caused this. Miss Steph say that's what I was saying. Just to forget something had to be wrong. Exactly. We was literally, not just you. I said that, a couple of people were saying that, especially early on in the trial, right? And then I think we start getting more like, not the pattern. And I must say this. I have to say this, you guys. I just have to. I am so proud of us and myself for being very committed to this content because I keep getting all these notifications, baby. And I used to be in time, if I wasn't committed to this channel, I'd be like, okay, I gotta go, something happened, you know. But now I see it and I say, okay, I'll just check it out after I'm finished. You know what I'm saying? So I just want to applaud myself for being so committed. And I definitely want to give y'all a standing ovation for being right here supporting me through it, sticking and staying. Thank y'all. I love y'all. Okay, don't tell nobody though. Let's go. Very interesting. I'm glad we listened to this part. Now, who is this man with that sour face? Look on his face. Let's see. This man right here. I promise to goodness. Look at that man. And this expression he got on his face right now. Don't he look just like one of those characters off The Simpsons? I don't know the name of the character, but right now with this man right there as how he looking on his face, don't he look just like one of the characters from Bart Simpson? Okay, Foot Soldier said, what type of investigation was done for what happened with the drowning? Well, they did some type of investigation, but what they decided, they came to the conclusion, Foot Soldier, because they didn't really talk about it, right? But they came to the conclusion that it was not criminal, it was just a simple tragic mistake, nothing criminal. So but they didn't really give us any of the details, and we really haven't heard any of the details about what happened in that. Okay, where's my cup of coffee I went to go get? Let's go. Oh, let me cut it up.
Would you state your name, please?
Ryan Estevez.
Okay, and how are you employed, sir?
I'm self-employed.
Okay, and what do you do for a living?
I am a general and adult and geriatric psychiatrist.
Okay, and how long have you been in that particular profession?
This will be my 23rd year.
Okay. Can you tell us, please, your education, training, and experience in the field of forensic psychiatry and other fields of psychiatry?
Sure. I initially got my bachelor's degree in psychology at Stanford University. Following that, I got a master's degree in social psychology, also at Stanford University. From there, I did my MD and a combined PhD in experimental health psychology and neuropsychopharmacology at Tufts University. Following that, I did an internship at University of Texas Southwestern Medical School in Dallas in medicine, psychiatry, and neurology. Followed that, I did my residency in adult psychiatry at the same place, University of Texas Southwestern. Following that, I did a master's in public health at Harvard University in Boston. And following that, I did a research fellowship at Harvard and UT Southwestern. Following that, I did a geriatric fellowship at UCLA Semel Institute for Neuroscience. And finally, I did a fellowship in forensic psychiatry at University of Florida, McKnight Brain Institute.
Okay. And are you licensed to practice medicine in the state of Florida?
Yes, I am, as well as the state of California.
Okay. And are you board certified in any certain areas of medicine?
Yes, I have 6 board certifications. The first is in general adult psychiatry. And I also have a subspecialty board certifications in consultation liaison psychiatry, geriatric psychiatry, forensic psychiatry, psychosomatic medicine, and addiction medicine.
Okay. And have you ever testified as an expert?
Yes, I have.
Okay. In the state of Florida?
That's correct.
Have any idea how many times?
I don't keep a notebook of how many times. I don't know, 100 times perhaps.
How many?
Tens, perhaps 100 times. It's in the tens.
Okay. You've also testified as an expert in other states.
That's correct, in
Okay.
California and Texas.
Okay. And you would testify in the areas of psychiatry?
The psychiatry, psychopharmacology, and geriatric psychiatry or memory disorders.
Okay. And did I ask you to evaluate Ms. Nix in this case?
Correct.
Okay. Can you tell us specifically what you did in order to evaluate her?
Sure. The process is the same as I do for everybody that I examine, in that if I agree to do an initial review of the case, I ask for all the medical records, any mental health records, and any other records that might be important, let's say jail records or anything like that, if they have a criminal history. And then I interview the individual, which I did with Ms. Nix. Interviewed her for several hours and did some preliminary neuropsychological testing. And following that, kind of review the record again, consult any literature that I might need to consult that might be helpful, and then form an opinion.
Okay. And can you tell us specifically your opinions that you formed in this case?
Sure. So, as I try to be as unbiased as I possibly can, but I must admit, there's an initial sort of visceral reaction to something like this case that happens. But you go and you try to figure out what's going on here. But I initially thought, okay,
spit it out.
Look at it like a puzzle, which often is a puzzle. What's
Wait a minute.
going on here?
He's doing too much. Hold on.
Said or,
I'm ready to get to the verdict.
Funded by the United Nations.
What the heck?
Because children have died and hundreds of children have.
Child, he gave me the whole speech. Who is this little man? He remind me of Martin Short. Y'all know Martin Short from the 80s movies with Steve
Take a
Martin.
name for the court, please.
David Diamond.
And how are you employed, sir?
At the University of South Florida. I'm a professor in the Department of Psychology.
Okay. And how long have you been so employed?
Almost 30 years.
Okay.
That's my
And can you
Tourette's.
tell us
My
your
bad.
education, training, and experience?
I wonder
in
if the
field
verdict
of
is on a different
psychology
screen.
or what other specialties that you may have?
I received an undergraduate degree in biology from the University of California, Irvine. And a
For so to
PhD
know, I
also in
didn't.
biology with a specialty.
I don't even
in
know who you're speaking of.
neurobiology
Actually, you
memory.
might have to
Also
drop it in
from,
my
University
drop it in
of
the
California,
comments.
Irvine at the Center for the
Is it
Neurobiology
recent?
of Learning and Memory. I had a postdoc at the Department of Pharmacology at the University of Colorado Health Sciences Center. And ever since then,
Sorry,
I've
y'all.
been a professor in psychology at the University of
I'm
South
trying to see
Florida.
if it's on a different video, the verdict. Might
All right.
be.
And what is your specialty, if any, sir?
My primary specialty is the study of the brain and memory.
Okay.
May I add that I've also been a career scientist at the Veterans Affairs Department for 30 years, with my specialty being post-traumatic stress disorder, which is fundamentally a memory disorder.
Okay. Can you give us a summary of your contributions to science?
So I have primarily studied all different aspects of the brain and memory. I've studied how people are affected by trauma and develop post-traumatic stress disorder. I've studied how the mechanisms of memory.
In cars, being left in cars?
Off the top of my head,
Let me go ahead now. We're gonna break this. I'm gonna
Yes,
get the verdict in.
Yes, sir.
Uh-oh.
Uh-oh.
Uh-oh. Sorry, I didn't mean to scare y'all.
No, Your Honor, I was just about to say, I didn't know if I heard the court correctly, but we have a verdict. So
We do have a verdict, and so you need to step down once we're done with the trial. Whichever way it goes, you can have the courtroom with the court reporter. So sir, please step down. All
Okay,
right.
sir.
Jump rules, we're ready for your.
The verdict is in, you guys. Two hours and 30 minutes.
All right. All right, everyone understand the verdict's coming in. We don't have a lot of trials on Wednesdays, so we just have some bailiffs that are going to step in and some other lawyers are going to step in just to see the verdict come in. Understand?
Yes, sir.
Thank you. All right. Is Pulos out there?
Yes.
Okay, don't bring me in. Okay.
Ready, Judge?
All right, yes.
All rise.
The verdict is in. The Lit Lane verdict was guilty of lesser charge, leaving the child in the car. Let's see what the actual jury comes up with.
All right, everyone have a seat. We're back on the record for State of Florida versus Tracy Nix, CF 22-289. Members of the jury, did y'all reach a verdict? Who's if my foreperson would raise their hand and hand the verdict to the bailiff. All right, defense, please rise. Mrs. Nix, please rise. All right, we're going to go ahead and publish the verdict.
In the Circuit Court of the 10th Judicial Circuit of Florida in and for Hardy County, State of Florida versus Tracy Howard Nix, case number CF 22-000-A000-XXW. Verdict form. We, the jury, find as follows as to count one of the charge. The defendant, Tracy Howard Nix, is not guilty. We, the jury, find as follows as to count two of the charge. The defendant, Tracy Howard Nix, is guilty of leaving a child in a motor vehicle in excess of 15 minutes, causing great bodily harm.
Don't read, don't read anymore.
Yes, sir.
All right, thank you. Mr. Fletcher, you wish
Boom.
to be polled?
No, Your Honor.
State, you wish the jury. to
And
be
guess
polled?
what?
No, Your Honor.
I'm going to release the jury.
No objection.
All right, all rise.
Let me see his head.
I want to give you your final instructions.
Winston.
Hold on a second. Ladies and gentlemen.
Put the eyeballs there
thank
to
you
yourself.
for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors such as yourself. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon jurors.
And there you have it, Lit Lane Jury Box. We have successfully completed another trial watch. Okay, we have really been making some waves over here and doing it. Okay, so in the state of Florida versus Tracy Nix, the verdict came back not guilty of charge 1, which was manslaughter. They found her guilty of charge 2, leaving a child in a motor vehicle for over 15 minutes, causing great bodily harm. I just want y'all to know what a great and terrific job and how close we actually came to the same conclusion as the Lit Lane Jury Box. The Lit Lane Jury Box verdict was the same exact one. Guilty of a lesser charge, leaving a child in the car. Okay? So, put soldier just said a bunch of idiots. So, we're going to go ahead and get ready to adjourn. I want you guys to know, as a Lit Lane Jury Box, you guys have served a great and excellent duty. You guys have showed up, answered the summons, listened to the heart, sometimes triggering testimony. You guys have been very open-minded, very opinionated, and very outspoken. And I just want to let you know, as the Lit Lane Jury Box, as the judge, Judge D. Lit, that I appreciate y'all service. Don't be surprised if you find yourself being summoned again, because one thing for certain, two things for sure. Justice never stops. It's always going. Thank you for tuning in to another Trial Watch here on Trial Watch with Demetra. Stay tuned and have a great weekend. Bye.
Thanks for watching. Do not forget click the subscribe button and hit the bell icon. Like, comment and share. See you next time.